1 in 4 Nigerians, an estimated 50 million people, live with some form of a mental health condition. Despite those numbers, for decades, the only law governing these citizens was the 1958 Lunacy Act, a colonial statute that remained in force long after independence. That law effectively criminalized illness. It allowed the state to officially label citizens as lunatics and permitted arbitrary detention based on the mere suspicion of a magistrate or medical officer. The turning point arrived in late 2022 with the signing of the National Mental Health Act 2021 into law. This document officially strikes the term lunacy from Nigerian law, replacing it with the medically recognized term mental health condition. This change moves mental health out of the penal code and into the healthcare sector, treating it as a matter of civil rights rather than a reason for criminal suspicion. To manage this transition, the Act establishes a mental health services department to coordinate care and set standards across the country. To address the lack of resources, it creates a mental health fund. This mechanism draws from annual budgetary allocations and corporate donations to ensure services are actually funded. Sections 22 and 23 of the Act extend these protections to daily life, guaranteeing the right to housing, education, and social inclusion. In the workplace, this means an employer cannot legally fire or demote an employee for seeking therapy or managing a condition with medication. The law also mandates strict confidentiality, ensuring that a patient's medical records and treatment history remain private. Instead of forced compliance, patients now have the legal right to help plan their own treatment and rehabilitation. It further guarantees access to essential psychotropic medications and therapy at all levels of the healthcare system. These specific protections allow citizens to seek medical intervention without the immediate risk of losing their livelihoods or their social standing. One of the most critical parts of the law defines how the state handles acute psychiatric emergencies and involuntary admissions. This logic flowchart illustrates the new threshold for involuntary care. Under Section 28, exactly 2 independent medical practitioners must examine a patient and sign the required forms before an involuntary admission can proceed. The Act also places strict new limits on physical restraint and forced seclusion, methods that were often abused under the previous system. There is now a 72-hour clock on any form of seclusion. Extending that period requires a formal petition to the Mental Health Assessment Committee. To enforce these rights, the Act introduces fines for practitioners and facilities ranging from 500,000 to 2,000 naira. Violators also face criminal penalties, including 1 to 5 years of imprisonment for those convicted of abusing patients. These penalties provide a legal framework to hold institutions accountable, shifting the focus from custodial control to patient safety. This map illustrates the current infrastructure gap. There are currently only 9 national neuropsychiatric hospitals serving the entire federation. The personnel shortage is equally stark, with roughly 300 psychiatrists available for a population of over 200 million people. While a new law cannot immediately produce more doctors, it does provide a specific blueprint for how the government must now fund and manage mental health care. It means that victims of abuse in traditional or faith-based centers now have a formal statutory pathway to file complaints and seek legal redress. A law only protects the people who know it exists. Its success depends on a public that is educated enough to enforce it. Share this information. By understanding these rights, you can help move the conversation from stigma toward accountability